Hey everyone, today I'm going to talk about limited liability partnerships which are governed under the Limited Liability Partnerships Act. This should be distinguished from traditional partnerships which are governed under the Partnerships Act. Now the Limited Liability Partnership, which I shall call LLP, is a business structure co-owned by two or more partners. Unlike a traditional partnership, the LLP has a separate legal entity similar to a private limited company, which is separate from its owners, and therefore the LLP itself can own property, can sue people, or can be sued in its own name. Section 6 of the LLP Act specifically states that the partnership law, that means traditional partnerships, will not apply to an LLP. So things like joint and severable liability on partners does not apply to LLP. The partners of an LLP will not be held personally liable for the business debts incurred by the LLP. A partner may, however, be held personally liable for claims from losses resulting from his own wrongful act or omission, but will not be held personally liable for wrongful acts or omissions of any other partner of the LLP. So let me explain this. In a traditional partnerships, there's this thing called joint and several liability. So if one partner does something wrong, all of them can be sued, or they can pick one or two, okay? But for LLP, if a bad partner does something bad, the other partners will not be liable. Only the partner who did the bad act will be liable under the LLP. That's one of the main distinguishing factors between an LLP and a traditional partnership. Compared to private limited companies, there is moderate compliance with ACRA, and LLP is required to keep accounting records, profit and loss accounts, and balance sheets that will explain the transactions and financial position of the LLP. In addition, the LLP must submit to ACRA an annual declaration of solvency or insolvency. That means whether it's able to pay its debts, which will be made available to the public. I mentioned earlier about limited liability, but now I'm going to talk about it in detail. Now, a partner during the course of the business of the LLP is responsible for liabilities that arise due to his act of commission, omission, or negligence. Liability claims can be made against him and his personal assets. That means if a partner is naughty, creditor can make claims against him and his personal assets. However, the innocent partners and their personal assets will remain separate and insulated from such liabilities. That's a distinguishing factor between LLP and traditional partnership. The partners of an LLP will not be held personally liable for any business debts incurred by the LLP. How is the relationships between the partners of an LLP governed? Well, in the absence of LLP agreement, the relationship between the partners are governed under the first schedule of the LLP Act. If you do not want the terms of the first schedule to apply, then you need to have an LLP agreement to set out the relationship between the partners, okay? How the partnership, the LLP is governed, how profits are shared, how what happens upon the death or the resignation of a partner. Now I'm going to talk about taxation of the LLP. An LLP is not taxed at the entity level, but rather the income of the LLP is taxed at the partners level at their personal income tax rates. Is it possible to convert a LLP to a private limited company to enjoy the benefits of private limited companies? The answer is yes. How do you go about doing it? Well, you just need to make an application with ACRA. You can look at the third schedule of the LLP Act for the requirements on conversion from LLP to private limited. So thanks for watching this video on limited liability partnerships.